Hi, I'm James Crowson with Crowson Law Group. I'd like to take a few moments to talk with you about the litigation process that we'll undertake whenever private negotiations break down. If you're viewing this video, it's likely that we're filing a lawsuit in your injury case, and that can be because we've reached an impasse with the insurance company regarding the value of your case, or the statute of limitations is coming up and we want to preserve your right to recovery by filing a lawsuit. Once we file a lawsuit, you can expect that the defendant will be served by a process server. That'll take a couple of weeks. Once the defendant is served, he or she will contact the liability carrier, who will in turn contact a defense lawyer to defend that case. There'll be an answer filed with the court. Usually that whole process, the service and the retention of counsel and the filing of an answer will take about 30 to 60 days. Once that document is filed, we'll have a pretrial hearing with the judge and the parties involved. And the judge at that hearing will set a court date. Usually that court date is about a year to 18 months after the date of the pretrial hearing. From the time that the case is filed until such time as we actually get in front of a jury will oftentimes be a year and a half or 2 years. Once the case is filed, we'll also have depositions, we'll have interrogatories and requests for production of documents, which are written questions that we have to answer. We'll be able to propound those same written questions to the other side. They'll have to answer those as well under oath, and that's part of the discovery process. We'll complete all of the discovery process before the trial date. In summary, what you can expect is from the date that we file the lawsuit, it'll be several weeks before we have an answer. After we have an answer, there'll be a judge appointed, and the judge and the parties will get together and decide on a court date that'll be about a year or a year and a half after that date. You're looking at about 18 months to 2 years before you'll be in front of a jury with a case. There'll be ample opportunity to complete the discovery and also to continue negotiations with the adverse party to try and resolve the case short of trial. It's important to remember that the filing of a lawsuit does not necessarily mean that we're going to court and we're going to be in front of a jury. Now, it certainly is the first step toward that process, and that's where things are heading. But there's a lot of time to negotiate, a lot of time to discuss with the adverse party the resolution of this case privately.